He knew each of the accused persons being PW1, sorry, A2, A1 for the possible charges against him. No authority exists for the propositions that the petitioners advance. There is nothing unconstitutional per se in preferring charges against a person that has been held for longer than 48 hours. That was what was decided in that case, and we have since settled that matter. The persuasive Kenyan authorities referred to by A1 with regard to his detention beyond 48 hours are in respect of the Kenyan constitution and not the Ugandan constitution, and that one has been settled also in that matter. Under our laws, as already stated above, failure to produce a person before a court of law to prefer a charge within 48 hours does not bar prosecution of that person. Now, for the allegations of torture raised by A1, this was settled within a trial that was held in this case. And the court made a finding that there was no torture against the accused person, and the statement or the charge and cautionary statement was properly made by him. In light of the above evidence adduced by the prosecution, there is need for the accused persons to defend themselves pursuant to Section 73, subsection 2 of the Trial on Indictments Act. Each of the accused persons is therefore required to defend themselves as required under Section 73, subsection 2 of the Trial on Indictments Act. They have three ways in which they can do that. They can give evidence on their behalf. They can make an unsworn statement or a sworn statement. They can call witnesses if they so desire. So their lawyers should be able to advise them more about that. As for Mr. Kasolo, I hope you understand that. Lubega Johnson, koti emundetere kubanga alibizira prison yevunanyizibwa. Owekitiibwa omulamuzi ku bajulizi bano abalala abataano, owekitiibwa omulamuzi nina kyensaba kkooti ekiramuzi enkolere ne baneesaba ekiramuzi kibeere ku likodi ku bajulizi bataano bano abasigadde nina mukaaga owekitiibwa omulamuzi. Bano abataano balina kyensaba kkooti ekiramuzi ne baneesaba okiteeke ku likodi nti nakisaba okusobola okubaleeta bano abajulizi owekitiibwa omulamuzi. Owekitiibwa omulamuzi ekintu kyebaze nsaba owekitiibwa omulamuzi mbadde nsaba kkooti owekitiibwa omulamuzi enfunyireyo $5,000,000 nsobole okukuba ekirango mu mawulire okusobola okuyita abajulizi bange bamu ekitiibwa omulamuzi abataano kubanga okuva lwe nakwatibwa owekitiibwa omulamuzi ndi mu pulizoni sidalamu kubawuliza sirina namba zaabwe za simu.
Oweekitiibwa Omulanzi ayanziza nnyo kkooti ekyomukiiko okunnyigira awali wasangibwa Oweekitiibwa Omulanzi abajulizi bano abataano aboogerwako nasembayo okubalabako oba okubeera nabo mu kifo we nali nkolera ku Mabiito e Nateete kubanga nabo bonna batembeeyi nasembayo okubalaba naye kubanga n'olunaku lwe bagamba omusango lwe gwaddizibwa nali nabo ng'akola kisaawa ezo. Oweekitiibwa mpozi sirina namba za ssimu zaabwe kubanga mu kiseera kiri we twali wetuli tetwalina nnyo nkolagana esingako okubeera awo tukolera nojja nemwebuuzaako sirina namba zaabwe ezozo era ne gye baali babeera sirinaawo wensobola kutwala nti ennyumba yeno naye nga bakuna lumanyi ebifo gye baayogeraga naye nga sobola kunyonyola nti ennyumba yeno bamaka bweri ati erosebe. Ekirabo Oweekitiibwa Omulamuzi omugalange siteeti kyayogeddeko ekyensaasaanya ya ssente z'ensaga miliyoni 5. Oweekitiibwa Omulamuzi ensaasaanya eri bweti. Oweekitiibwa Omulamuzi ekirabo kye ngenda okukuba Oweekitiibwa Omulamuzi ngenda kukiteekako mu mpapula z'amawulire Oweekitiibwa Omulamuzi era mu mpapula ezo nga mulimu obukadde olupapula New Vision Red Paper Daily Monitor Sekadolia Olumuli
the following starting
mulimu obukadde olupapula mulimu New Vision olupapula n'olupapula lwa Observe ngenda kuteeka ne mu lupapula lwa Good News ngenda kuteeka ne mu lupapula lw'Olumuli ngenda kuteeka ne mu lupapula lwa Daily Monitor nsembyeyo n'olupapula olwa Wino olwa Wino Oweekitiibwa Omulamuzi era ngenze empapula ngenda kukozesa miliyoni 10 okubalabala. Oweekitiibwa Omulamuzi ekiranga ekirala ngenda kikuba mu mikutu gya TV ez'enjawulo era nga mu TV omwo ngenda kusookera ku UBC teekayo ekirango ngenda kutwala ku NTV teekayo ekirango ngenda kutwala ku TV West nayo teekayo ekirango ngenda kutwala ku Solos TV teekayo ekirango ngenda kutwala ne ku Spark TV teekayo ekirango Oweekitiibwa Omulamuzi era nga nabaze Oweekitiibwa Omulamuzi nga ku TV ezo ngenda kukozesa miliyoni 2 ezo TV. Oweekitiibwa Omulamuzi ngenda kuba ekirango ku leediyo ku leediyo nga ku leediyo Oweekitiibwa Omulamuzi ze ngenda okutandikirako ngenda kutandikira Obukadde FM ngenda kukuba ekirango ku CBS ngenda kuteeka ekirango ekirala Oweekitiibwa ku Kaboozi FM era ngenda teeka ekirango ne ku leediyo 1 era ngenda teeka ekirango ku Sanyuka FM era ngenda kuteeka ekirango ku Beat FM. Oweekitiibwa Omulamuzi ngenda teeka ekirango ekisembayo ku Super FM era nga nawe Oweekitiibwa Omulamuzi nabaliddewo miliyoni 10 ya social media omikutu ebyo Oweekitiibwa Omulamuzi omukutu ogusooka gwa Facebook nateekayo ekirango nakuta abajulizi bange. Oweekitiibwa Omulamuzi omukutu omulala gwa WhatsApp Wekitiibwa omulamuzi omukutu omulala TikTok wekitiibwa omulamuzi ne ku Instagram era nga nawo nginakozesa miliyoni 10 wekitiibwa omulamuzi miliyoni 5 zensaba kkooti era zirina mukama wange wekitiibwa omulamuzi kkooti ezibbega musobole okuyita abajulizi bange okunyigala omusango ekitiibwa omulamuzi era njagala okutegeeza kkooti eno disitulikiti yalabika alina engeri gyalabamu ebintu bye naye ekitiibwa omulamuzi guno si muzannyo oba kusaaga wabula ndi ku nsonga entuufu yenyiga ekitiibwa omulamuzi gyerimu.
As a matter of right, my Lord, Section 75 of the Trial on Indictments Act, and with your leave, my Lord, allow me to just read it verbatim. My Lord, Section 75 is what governs the aspect of witnesses for the defense. And it provides that the accused person shall be allowed to examine any witness if the witness is in attendance, but he or she shall not be entitled as of right to examine any witness, but he or she shall not be entitled as of right to have any witness summoned other than the witnesses whom he or she named in the magistrate's court committing him or her for trial as witnesses whom he or she desires to be summoned. My Lord, I can just...
Let me just repeat that. So
yes, I can.
I was reconsidering.
Section 75 deals with, of the Trial on Indictments Act, deals with witnesses for the defense. It provides that the accused person shall be allowed to examine any witnesses if the witness is in attendance, but he or she shall not be entitled as of right to have any witness summoned other than the witnesses whom he or she named in the magistrate's court committing him or her for trial as witnesses whom he or she desires to be summoned. My Lord, there are two things here. For the defense, they can call any witness if the witness is present. That by implication puts the burden of having their own witnesses in court on themselves. My Lord, this court can allow as many witnesses as they desire if those witnesses are present in court, if they produce them on their own. My Lord, that is the first aspect. Now the second aspect is other witnesses can be summoned. If they are not present, they can be summoned. If those witnesses were named during the committal proceedings. So the question that this court should be addressing ourselves itself is, are the six named, 6 or 5? 5 named witnesses, were these witnesses disclosed to court in a magistrate's court where the accused was being committed? Did he envision them? Did he mention them as witnesses that would require during his defense? My Lord, if the answer is no, then this court has no obligation within the law to summon them. And my Lord, with is a question of law. First, he does not have the right to cause the summoning of any witnesses he did not mention. My Lord, our record shows that A1 never mentioned any of the people that he's mentioning now during the lower court proceedings for his committal. We are just realizing it now, my Lord. He never mentioned any of this. And my Lord, because it is a question of law, we now vehemently object to his prayer to summon persons that he never mentioned or disclosed in the lower court.
We oppose those.
The prayers for him to summon persons that he did not disclose at the time of his committal. And my Lord, this honorable court has the record of the lower court, and this can be cross-checked. My Lord, you will find that Mr. Kasolo never indicated any of these witnesses. His failure to have named them in the lower court deprives him of this right that is, you know. And in effect, since he has no right to summon them, his expenses will have no legal basis, my Lord. He can only claim for the expenses if he indicated to the lower court. So, in other words, my Lord, we are saying court should consider section 75 and make a ruling that he has no right at all to summon people he never mentioned.
In the meantime, we shall go for
Out the trial. All the prosecution witnesses have been led in his presence. He has cross-examined each one of them. No new fact is arising. His defense is based on what the prosecution witnesses testified in his presence, and he able to cross-examine. We propose that, Lord, my Lord, the 16th, as agreed between us and the rest of the other 50 persons, is sufficient time to enable him to prepare to begin his defense. My Lord, 16th basically is a week from, slightly more than a week from today. That should be sufficient now.
for the other accused persons, but this one must give his testimony before. So we are giving him up to 16th. Everything you will start on the 16th. So you prepare yourself before that time so that you come here ready to proceed. So we are fixing the matter for hearing, defense hearing, starting with Ewa that day. Okay, you can, where is the clerk? Is it there? On the 16th day of May, 2023, this person is a further remanded. A1 is given the proceedings so far. So prepare yourself and yourselves for that matter. Of course, we are going to. He's in the court. As you heard him saying that once he's in the court does not need to spend on him. We shall tell him, are you not willing to be his witness? And before we start calling other witnesses than yourselves, I have given a ruling on that. Okay. Should have been caused and the unlawful actuated by malice, and lastly they anticipated the production of a post-mortem evidence of Thank you.